All right, good morning, everybody. It's almost 6 or just turned 6. I'm going to give it a few more minutes to see if anybody else decides to come join. But in the meantime, please just make sure that you have yourself muted so there's not a bunch of feedback, and we'll get started.
Oh, my goodness, sounds like yours.
Yeah. Common law.
All right, so it looks like we have the initial batch of people that will be joining us for tonight. So we'll go ahead and get started. So first off, my name is Pealey Long. I'm a senior attorney here at Rizzo Law PLC, and I am our department lead for association enforcement and litigation matters. So basically anything dealing with an association, whether plaintiff side, defendant side, and particularly regarding enforcement issues, those matters normally, route through me, and we have a number of attorneys who will work on those matters. So as you can see, the topic of tonight's seminar is common bylaw violations and how to handle them. Probably one of the hottest and highest priority issues for many of our associations. So I'm sure you will probably see many issues that you yourself have had to deal with in these slides, and possibly you haven't experienced them yet, they might be coming down the pipeline for you. So hopefully we'll be able to give you some tips and tricks for how to handle those when they come your way. In terms of today's presentation and participation, I'm going to be asking questions throughout my slides. So right now I put you all on mute so that way we don't get any feedback, but when we get to those questions on the slides, feel free to either unmute yourself and participate, or if you'd like to put your answer in the chat box, you can do that as well, just so that way we can get an idea of what everybody thinks about these different bylaw violations. Throughout this seminar, webinar as well, if you have any questions on particular matters, feel free to put them in the chat box, or you can hit the raise hand icon that's available on Zoom. Please don't raise your hand on the video because I can only see like 5 of you at one time. So I'm probably not going to see you unless you're one of the lucky 5 who are on my screen right now. But if you don't want to participate or ask questions during the presentation, I am going to open it up at the end. So feel free, you can also hold on to them until the end of the presentation. So with that said, we are going to go ahead and get started. And then just so you know, I'm also handling the chat box, looking at my screen as well. So trying to make sure I account for everybody's questions as they come up. So in terms of tonight's presentation, we are going to be covering the following issues, which we tend to see most often pop up in bylaw enforcement matters. And so those start off with pets, short-term rentals, and leasing, marijuana and smoking, parking and towing, hoarding and trash, unauthorized modifications and alterations, security cameras, ring doorbells, and signs and lawn ornaments. And so if you are a board member or a property manager participating, you have probably seen almost all of these, if not all of them, and probably more than once. So first off, one of the highest topic button issues that we always deal with are pets. And so there's two aspects regarding pets that we typically see that our associations typically deal with. First are size and weight restrictions, and the second is the ever-growing request for emotional support animals. So first, we're going to start off with size and weight restrictions. So here we have a lovely story of David the dog lover who lives in a condominium that prohibits pets over 40 pounds and its rules and regulations. David decides this rule is preposterous. So he goes ahead, buys a newborn dog that initially weighs 15 pounds, but over time, the dog ends up growing to be 100 pounds. And the association tells David he's got to get rid of the dog because it's too big. So the initial question that we have here is, can David keep his dog? So if you want to unmute yourself or put your thoughts in the chat box, feel free and let me know your thoughts. Or maybe everyone's just anxiously waiting to hear what the answer is going to be. So while I wait to see more responses, one person did ask in the chat box for clarification between bylaws, whether those be condominium bylaws or just bylaws in general, if you're a subdivision, versus rules and regulations. So in this case, as you can see, there's a little note at the bottom. There was an unpublished case out of the Court of Appeals that dealt with a similar issue. So in that particular instance, you had a condominium that says, or condominium bylaws that don't say anything about pet size and weight. And the association adopted rules and regulations that said, hey, we're going to have a size and weight limit restriction. And the Michigan Court of Appeals in Bear Creek Village Condo Association versus Clark said, hey, those rules and regulations are not reasonable. And so you can't restrict pet sizes and weight via rules and regulations. And so in that instance, the co-owner was not required to remove their dog. And so in this case, we have a similar situation. The Condo Association adopted size and weight restrictions via rules and regulations. And so it's very likely in that case that David will be able to keep his dog. And so, in answering the next question, let's just say that this rule and regulation was found to be reasonable and enforceable. Would it matter if the fact that when David bought the dog, it was only 15 pounds and then grew to be 100 pounds? No, not necessarily. And then we come to the last question of what if the size restriction was in the condominium bylaws? So this is a little bit more of a gray area because we have not yet seen a Court of Appeals case in which somebody has included size and weight restrictions in their bylaws. And then that case has gone up and it's been determined whether or not, even if they're in the bylaws, whether they are reasonable and enforceable. So certainly we generally recommend to our associations, particularly when these provisions are either already baked into their bylaws or if they're considering adding them to their bylaws, that they consider this may or may not be enforceable. There is a potential risk in them, but if you're going to require size and weight restrictions, you cannot do it through rules and regulations. You likely are going to have to do it through the bylaws, but there is some gray area as to whether they still are reasonable or enforceable in your bylaws. So with that said, we will now move on to the next always fun topic of emotional support animals, which I'm sure many of you have seen requests for, especially if you have pet restrictions over the last several years. So in this case, Tanya subdivision has a deed restriction that prohibits pets. She was assaulted as a teenager and has been prescribed an emotional support animal, a dog, for emotional support. She requests a reasonable accommodation to keep her dog. The association denies Tanya's request because her dog violates the deed restrictions, and they file a lawsuit to have her remove the dog from the subdivision. Is Tanya entitled to a reasonable accommodation to keep her ESA dog? So if you want to put in your guesses in the chat box, or if you want to share it out with the rest of the group, feel free to do so. So we have one person here who's answered yes, no. We have another one who's answered yes, yes. So far, the consensus looks like Tanya is going to be entitled to a reasonable accommodation. And I would agree with you. So this emotional support animals are subject to the Fair Housing Act. And reasonable accommodations that are granted under the Fair Housing Act. And in order to request a reasonable accommodation, the requester, or Tanya in this case, has to demonstrate three things. First, that she has a disability. The Fair Housing Act has a specific definition of a disability, so you wouldn't necessarily look at the ADA. The Fair Housing Act's definition is generally that if there's some physical or mental impairment that substantially limits one or more of their major life activities. Here, it seems that we don't know exactly what her diagnosis is, but it does seem like she might have some emotional or mental impairment from being assaulted as a teenager. And so she requires some sort of emotional support from that particular incident. The second thing she has to do is she has to describe the accommodation. And this is one that most co-owners and homeowners are easily going to satisfy because they're going to say, I want my dog, or I want my emotional support cat, or whatever the particular animal is. And then the third item that she has to satisfy in her request is she has to identify the relationship between her disability and the accommodation that she's requesting. So basically, she has to be able to identify how that accommodation is going to alleviate her disability, the symptoms of it, and basically help her to enjoy living in her residence and enjoy her dwelling. So in this case, there's a particular, we have here of, she's been prescribed an emotional support animal. Most of the time, these requests are supported by a doctor's letter. And so there seems to be some indication that she does need this particular emotional support animal, to go about her daily life and her daily function. So in this case, it's very likely that she's going to be entitled to a reasonable accommodation to keep her dog. And in terms of having to remove her dog, that answer is likely no. I do see some questions on this issue that I'll bring up. One of which is, what if your association allows animals, but the dogs are allowed to violate the rules? They're running around, maybe dog waste is not being picked up. So generally, while you might have to make some exceptions and allowing a person to have an emotional support animal subject to whatever number of restrictions or type of animal restrictions you have, they still are required to comply with the bylaws. So yes, they can have an emotional support animal, but if you have rules on pet waste and removal, or they have to be leashed on the common elements, they would still need to comply with those particular requirements. And then also somebody says, what if a board member wants to bring their emotional support animal to a meeting in small quarters and someone is allergic to the animal? So in this case, it sounds like we may not necessarily be living in a particular dwelling and dealing necessarily within a particular dwelling, but participation in a meeting that may or may not be off-site. And so, to the extent that would require, the board member to bring their emotional support animal to the meeting in order to participate in the meeting, that will probably require some balancing of the particular interest here. A board member gets to participate in the meeting, but this other individual likely gets to participate in the meeting as well. So hopefully those two individuals would be able to, find some common ground and work out some accommodation, whether maybe one person decides to participate remotely, or, maybe they agree to kind of spread themselves out to hopefully limit that interaction. All right, so the next one, and this is just to provide some general guidance here. So emotional support animals and denial of reasonable accommodation request is basically the number one issue that comes up with the housing Department of Housing and Urban Development. And so at the beginning of January 2020, the HUD issued some guidance, and I've included the link here, but you can also type in this language here: assessing a person's request to have an animal as a reasonable accommodation under the Fair Housing Act. So that is a very detailed, multi-page document from HUD outlining specifically for housing providers like the associations, each step of the way, how to assess a person's request, providing guidance on whether or not they can request, what information they can request that a co-owner or a homeowner provide, and kind of, hey, if you have enough information, you might have to grant the request. You may not have enough information in this particular circumstance. And so, you might be able to request this additional information. And so I think that that's a handy document for associations to have, just to get a better idea of how the process works, and generally what you can ask for from your homeowners and what you can't. So many times associations will say, I want their medical records. You can't ask for that information, but you can ask for other pieces of information to verify whether or not they have a disability. And so in addition to that document, if you do get a request for an emotional support animal or even a service animal, we just really recommend handling these requests with care, just because they do have the potential to result in housing discrimination claims and claims brought under the Fair Housing Act. And so those might be ones where you reach out, to your attorney to provide you with some guidance on, how to proceed with that particular request. So that's what we have for animals. We'll now go into another big item that we see here in Michigan, especially with our lakefront and up north properties, are short-term rentals and leasing. And so two issues that we're going to discuss are first short-term rentals, and the second is how to address a high number of rentals in your community. And actually, before I move along, I see here, going back to animals, there's a question about what about breed restrictions? And so generally what we recommend is, if an association wants to prohibit certain breeds of, particularly dogs is where we see these, from being brought into the association, then those breed restrictions be listed within your bylaws, whether they're condominium bylaws or if you're a subdivision, your declaration. So if you're going to restrict based on breeds, we recommend that that be included within the actual recorded documents, rather than just rules and regulations or a policy. When it comes to the Fair Housing Act, If you have a person who has maybe a breed restricted dog who wants to request them as an emotional support animal, if they satisfy all the requirements of the request, the association's likely going to have to grant that request. And HUD in the case law out there has, specifically advised that you can't necessarily describe, or you can't necessarily prohibit a request just because of the dog's breed, especially if that dog itself has not demonstrated any vicious or aggressive conduct. So there have been cases where, associations have said, that's a pit bull, we're not going to grant your emotional support animal request. They're dangerous dogs. And HUD and other courts have said, well, you can't just base it based off their breed and what their breed may be known for, unless you can point to actual dangerous conduct from this particular dog. So that's something to keep in mind as well, especially when dealing with emotional support animal requests and particular breeds of dogs that you may find or may have a reputation of being dangerous. So moving forward, and I will just go back to somebody asked, if an ESA or emotional support animal bites someone, is the owner exonerated? And I would say likely not, because while they may be allowed to have the dog in the condominium, they still are ultimately responsible for that dog and for that dog's behavior. So ultimately, that person's still going to be responsible for their dog. All right, so short-term rentals. So this is particularly important, like I said, because these have been increasing in numbers recently, and there's always seems to be upcoming legislation or possible legislation permitting short-term rentals in Michigan, or at least to a broader degree. And so, as you can see, this is just a list of some of the short-term rental websites. Sometimes it can be difficult to keep track of all the ones where co-owners and homeowners can rent their property. And so when you tend to see these short-term rentals and potential enforcement or prohibition of them, particularly problematic when we have associations that don't have an express prohibition on short-term rentals in their documents, or if they don't have, a minimum lease or rental term that would basically push out short-term rentals. So this is particularly true in typically subdivision declarations that don't specifically address leases or rentals at all, but instead might just have a provision that says, this is limited to residential use, single family private residences, and maybe also have something too that says, there aren't going to be any commercial or business uses. And so, of course, if you have something that expressly bans short-term rentals, you can rely on the language within that document. But if you have these residential use and commercial use restrictions, you're not necessarily prohibited, or I should say, you're not necessarily restricted from trying to prohibit short-term rentals, but it becomes a more nuanced argument that you have to make. And so here we see Michigan case law specifically says that you can restrict residential and commercial use of property, and that generally a commercial use restriction is going to prohibit more conduct than just a residential use restriction alone. And so ideally, especially in dealing with short-term rentals, you would have both restrictions. Though I should say, and we can discuss it in a little bit in a few slides, there have been cases where associations just have residential use restrictions, and they've still been able to prohibit short-term rentals in the community. And so one of the major cases regarding short-term rentals, particularly when a community only has residential use and commercial prohibition restrictions in their documents, is Eager versus Pealey. And so this was a 2-1 majority published opinion out of the Court of Appeals. There is a dissent, but it still holds true to this day, has not been overturned. And this was a community that only had those restrictions, did not have something expressly prohibiting short-term rentals. And the majority opinion said, hey, you can't have short-term rentals here. That's a commercial use. Yes, maybe people are coming and they're staying at your house for a few days and they're sleeping and they're eating there. And that activity kind of looks residential. But at the end of the day, this is really just a money-making venture for you. And people are just coming and going. There's no permanent presence to the short-term renters. And so it's a commercial use, and you're not going to be able, you can't have short-term rentals in the community. Of course, there is a dissent, which reflects the argument that this use does kind of look residential. So maybe there's an argument there, but generally this is the case law that has come out and has been relied on several times since then, to support short-term rentals being prohibited under definitely commercial use restrictions, but also residential use restrictions as well. And so some of the factors that will come into play, I will say that these issues are very intensely factual. And so when there's a dispute over them, they can result in litigation, because most of these questions that you see on the screen come up and really play into whether that short-term rentals in the community are a commercial use versus a residential use. And normally the facts that will swing one way or another are, is there an exchange of money? Are these, are you just allowing friends and family to, stay, or are you listing this rental on Airbnb, VRBO for most of the year, and you're, garnering substantial sums of money from renting these? Another thing is, does the owner claim a principal residence exemption on the property? So is this a property that primarily the co-owner or homeowner is living in as their principal residence, and they're just using them, or just doing some one-off rentals here and there throughout the year? Or do they own a property in another state? They kind of come visit this property, but most of the time it's being rented out to other people. Another thing as well that can be kind of dispositive of the type of use is who actually owns the property. Because sometimes you will have people who own the property through an IRA, and not all are IRAs, but some IRAs prohibit the person who holds the IRA from actually living in the property. So you have, a pretty strong argument there of, this is an investment property. You and your family cannot live in this property, and you can basically only rent it out to other people. So that's not a residential use, and that's strictly, a commercial use. Tied along with that, do they reside on the property at all? If they do, how long? Are they only there like 10 days out of the year, and then renters are there 90, 100, 120 days out of the year? Those things become important as well. And also, what type of insurance does the owner have on the property? Particularly if they plan on using it as a commercial property, a lot of times they'll have a commercial policy on it, not necessarily a homeowner's policy, but a commercial insurance policy. And so it kind of gets into a little bit of the weeds here, but more or less this is to say, even if you don't have an express prohibition against short-term rentals in your governing documents, if you do have recorded residential use or commercial use restrictions, there may still be an argument to prohibit short-term rentals in your community. One person asked, this talks about deed restrictions. Can it be further restricted by your bylaws? And so my answer to that would say, it depends. Which is a very lawyer answer. And but really it depends on how are those bylaws promulgated, who is voting on them. And at the end of the day, if it's not in a recorded restriction, such as your declaration or your master deed and your condominium bylaws, it likely would be challenged as an improper expansion of the recorded restrictions. And so typically you're going to want to see a restriction on use or a restriction on short-term rentals and a recorded declaration or in a recorded master deed and condominium bylaws. All right, and then just to touch briefly on addressing high number of rentals in communities. So, some associations don't necessarily see an issue with short-term rentals, but they see an issue with a lot of renter-occupied properties. And to the extent, that you're a community that really wants a lot of owner-occupied units versus renter-occupied units, there are a few different options you can use to try to encourage owner-occupied units versus renter-occupied units. Some of those come through, doing rental caps with hardship exceptions. So saying, only 30% of our units are going to be rented at any given time. And so if someone wants to rent and we're above that cap, you're not going to be able to rent, except if you have this limited circumstance, such as maybe you have to relocate for work. Maybe you need to temporarily, go to a nursing home or facility, but to at least limit the number of rentals at any given time. There's also too, sometimes you will have homeowners or particular co-owners who have bought up, multiple units and lots. And so clearly the goal there is to try to rent those properties. And so there may be, a restriction that you might want to add, limiting the number of units or lots they can own in the community, or you don't want to limit the number that they can own in the community, the number that they can rent or lease at any given time. So if they own 4, but they can only ever rent 1 at any time, they're not necessarily going to be encouraged to, own more than that singular property. And same thing too for corporate ownership. So many times we'll see corporations, hold the property, own it, and then turn around and rent it. There can be amendments that place restrictions that basically say, hey, okay, I recognize your corporation owns this entity, but you have to identify one person who gets to occupy this unit, and they have to occupy it for whatever the minimum initial lease term is. So whether it be 1 year or things like that. So those are some different options. There's lots more, and you can do lots of different things to try to accomplish that. So earlier I saw a raised hand, but I think it went away off my screen. But I do see a question here of, can you mandate that the owner live in the property for 1 year before being eligible for a rental? You can, but you're going to have it in your declaration or in your condominium bylaws. And that will be the same thing for all these particular options on the screen as well. If those restrictions aren't currently in your documents, you're going to have to go through the amendment process to provide for those. But that is something that you could require. All right. So anybody else? Questions on leasing or rentals? Okay, so somebody asked the question, what about roommates? So Dana, can you clarify that a little bit more for me? All right, while I wait for Dina. Okay, a single family unit, can they be prohibited from having roommates? Okay, so I think, first of all, when thinking about these restrictions, you have to think about what is enforceable. And so in this particular instance, if you have a restriction on the type of people who can live in the unit versus can you have a roommate, can it only be people who are related to one another, that may be really difficult to enforce and really difficult to find out. But typically, if you're going to enforce a single family, residential use restriction, sometimes you can look at occupancy standards from the zoning ordinance. So, maybe your local community's zoning ordinance defines single family as if you have 2 bedrooms, you get 4 occupants. If you have 3 bedrooms, you get 6 occupants, whatever that might be. And so I would just kind of caution thinking about when you're creating restrictions, are you going to be able to enforce them? Are you going to be able to track that down? So for again, example, are you going to be able to figure out who all those roommates are and how they're related to one another? And then I see here another question. So another person said that they have proposed bylaws that someone can only rent their unit every 3 years, whether or not they stay for the whole 3 years. And they said this is how the board tried to get around definitions of who would be family and how long they could stay. And what do we think of that? I guess my question would be kind of what exactly this was intended to enforce. And so I think I'd like to hold that to the end of the presentation so we can kind of discuss that in a little bit more detail. All right. So another hot topic, on to smoking and marijuana. So in this case, we have Ganja Gary, who owns a unit in the High Times condominium. Michigan has legalized recreational marijuana, and Gary smokes pot every day. The hallway constantly smells like pot, and the manager receives numerous complaints. The bylaws prohibit a co-owner from smoking in the condominium or causing a nuisance and permit fines for violations. The manager sends Gary a letter fining him $25, but he refuses to pay the fine because he claims that his conduct is legal under state law. So, does the state law supersede the bylaws? So feel free to drop your comments down in the chat box and let me know your thoughts. Can Gary smoke recreational marijuana in the condominium? We have one person who thinks yes. All right, so a few people, this is going kind of both ways here, relying both on whether it being federally legal under state law, noxious, offensive behavior. Okay, so in this case, the state law is not going to supersede the bylaws. So here we have a specific restriction. Well, first, we do have a specific restriction that they can't smoke. And so he is smoking, and so that bylaw restriction would apply to him. We don't have here whether they or not they have a provision prohibiting illegal conduct. But one thing that has become particularly prevalent in states that have legalized either recreational or medical marijuana is that marijuana is still illegal under federal law. And so while it may be legal under Michigan law, technically federal law still trumps state law. And so while he may be in compliance with state law, he is out of bounds in terms of federal law. And so in this case, the condominium can still restrict, permissible conduct, including smoking of recreational marijuana. In terms of the next question of whether the fine is valid, what are your thoughts? Is this fine? The manager sends him a letter, says you're fined $25. Is that fine going to hold? Okay, we have some people saying yes. Depends on the documents. It always does, which is very annoying, but It certainly does. All right. So in terms of the fine, and some people have asked about medical marijuana, that is coming up, so stay tuned. But in terms of the fine, this is a condominium, and the Michigan Condominium Act says that in order to levy a fine, you have to hold a hearing. And in this case, the manager just levied a fine, but it doesn't look like he held a hearing for the co-owner. And so this is something that many associations get tripped up on because, of course, it's very easy to just send a notice of you violated the documents, here's your fine. Sometimes associations will say you have a right to appeal it, or if you'd like to come, meet with the board to discuss it, you can if you want one. But the Michigan Condominium Act, so this is particular for our condominiums. Michigan Condominium Act does require before you're going to levy a fine, you have to give the co-owner opportunity to appear before the board. So if you're going to issue your notice of violation, you can send it to them, but you also need to say, hey, the board's going to hold a hearing on this fine or on this violation, and you have an opportunity to attend it and present a defense if you want. If they don't show up, you can still proceed in determining whether or not a violation did occur. So them not coming doesn't necessarily mean you can't move forward on it, but you do at least have to give them that hearing. Now, if you're a subdivision, you're not bound by the Michigan Condominium Act, so you'll need to look at the particular requirements within your documents and make sure that you follow those. Somebody asked, does any fine require a hearing? So if you're a condominium, at least for the initial fine, yes. So if there's a violation of one particular provision for that initial fine, you should definitely have a hearing. And then we generally recommend adopting a fine policy that says, any subsequent violations of that same provision, it will continue to go through the fine schedule, but, there won't be any additional hearings at that point in time. All right, up next, question on everybody's mind, Fair Housing Act and medical marijuana. So Devin, Evan, and Schmevin sit on the board of the Leafy Greens Condominium Association. Smokey is a stressed co-owner who suffers from anxiety. And the condominium documents ban smoking, but he has a medical marijuana card. He requests a reasonable accommodation under the Fair Housing Act to smoke marijuana in his unit and has a note from his doctor that marijuana will help ease his anxiety. So a debate ensues. Devin says marijuana is illegal, denied. Evan says medical marijuana is legal in Michigan, granted. And Schmevin says the doctor's note looks legit to me. I want to be a good neighbor, so maybe we should call the police to see if this is legal. So what should the board do? Should they grant the reasonable accommodation or not? Feel free. Someone said to call me. All right, absolutely. always smart. Talk with an attorney ahead of time, especially again, as I said earlier, Fair Housing Act issues can be particularly problematic sometimes. All right, I'm also trying to erase, there we go, get these off the screen. Someone said, marijuana could be ingested versus smoked. Someone thinks medical marijuana would have to be allowed. All right, so in this case, again, we've talked through the Fair Housing Act requirements. You have to show you have a disability. Here, Smokey has anxiety. You have to describe your requested accommodation. He wants to smoke marijuana. And then when it comes to, the connection between the two, the smoking of the marijuana is going to decrease his anxiety, and he's got a doctor's letter. So everything seems to be in Smokey's favor. However, again, even medical marijuana is still illegal under federal law. And one federal court in Michigan has said, basically, a housing provider does not have to grant an accommodation that violates federal law. So in this case, the association does not have to grant him a reasonable accommodation to smoke medical marijuana based on the fact that it remains illegal under federal law. And so when it comes to the second question, does it matter that it's medical marijuana instead of recreational marijuana? Not in this particular case, no. Because again, it's still, both forms of it are still illegal under federal law. So in this case, you know, they won't necessarily have to grant the accommodation. And since the condominium documents ban smoking, you know, he'll be in violation of the bylaws. All right. And then somebody else asked about growing marijuana. And so we've got all your bases on marijuana covered tonight. So Chief Chuck becomes emotionally distraught and simply cannot handle being on the Walla Walla condo board anymore. He resigns and starts a recreational marijuana business. And the condo bylaws prohibit illegal activity, but Michigan has just legalized recreational marijuana. He sets up some grow lights in his basement. And to save money, he plugs into the electrical outlet outside of his unit. And the association's electric bill increases $10,000 the following month. So can Chuck grow this marijuana? Big emphatic no from one person. All right, let's see. All right, and someone mentioned, you know, you might have to be licensed to grow in order to sell it. So here the answer, if we haven't hammered it home enough tonight, I'll say it again. Marijuana use and growing is illegal under federal law. And so even though it may be permitted in some circumstances under state law, it would still be illegal activity that the condo association could issue a notice of violation for. And one thing that I will note, and it has become for some of our associations, issues of marijuana, especially in light of the conflict between federal law and state law, can become pretty, you know, a careful balancing act, because some associations don't want to get in the middle of it. They don't want to actively go around and tell people to stop smoking or ingesting or using marijuana in their units or on the common elements or any common areas, you know, based on the fact that it is legal under state law. And so we just recommend that generally the safest, most cautious approach is to follow federal law and to say it's illegal under federal law. And so that's the tactic that we're going to take. But if the association decides it wants to take a different tactic, we just recommend, of course, reaching out to your attorneys to kind of talk through the pros and cons of that approach, because there is some risk under federal law if you're actively permitting use of marijuana in your condominium. But, you know, at the same time, some associations, you know, may be willing to take that risk, and some communities may want to permit it. And so again, just depending on which side of the fence you decide to go on this, just reach out to us or to your other association attorneys and talk through exactly what that would look like in your condominium or in your subdivision. All right. So then the second question is, can the association recover $10,000 from Chuck for all of his electrical usage over the past month? And so the question, or the answer to this question is, of course, it depends. And that depends on the provisions that are within either your declaration or your condominium documents. So in this case, there's, you know, typically we have provisions, or we recommend having provisions that say that the association has a right to assess and recover costs for any expenses that were incurred because of a particular homeowner's conduct. So in this case, a provision like that, you know, the association only incurred these expenses because Chuck decided to install grow lights, and he exponentially increased the electricity bill. And so having that provision, the association would be able to assess him and hold him responsible for that $10,000. Other provisions that we recommend, especially for utility usage, whether it be electricity, water, other things of that, particularly in associations where the bill's coming to the association and not to the co-owners. We typically also recommend having what's called a waste provision, which basically says, hey, if there's an increase in the usage of this utility and we can track it back to, this particular unit or lots, we're going to assess those costs back to you and hold you responsible for that. So generally, we recommend having those particular provisions in there. So you can make a very strong argument of if you're going to increase the utility usage, you're going to be responsible for it. All right. And then somebody asked about smoking in general, if it could be forbidden in the association. And that is a lovely segue into my next slide, which is just smoking in general. So Sandy the smoker, she's been a lifetime smoker. She lives in an attached condominium building. April suffers from asthma and begins demanding that the association prohibit Sandy and any other owners from smoking in the condominium. The bylaws are silent on smoking, but the board sees that they have authority to pass rules and regulations regarding activities within the condominium. So they pass a rule banning smoking within the condominium and file a lawsuit to force Sandy to stop smoking. Will she be forced to stop smoking? Someone's not sure that this will be able to be done via rules and regulations. Someone commented you can't restrict by rule tighter than the bylaws. And another person answered no. So in this case, the answer is likely no. So this is kind of similar to your pet weight and size restrictions. There's not a prohibition specifically within the recorded condominium bylaws. And so your rules and regulations are really supposed to be tools that implement existing restrictions either within your declaration or within your master deed and condominium bylaws. They should not be, your rules and regulations should not be creating new restrictions or burdens that don't already exist in your recorded documents. So here in this particular case, the documents are silent on smoking. And so if the board is going to want to ban smoking within the condominium, they're going to have to do so through a bylaws amendment. And somebody asked, what if Sandy has ADA protection? ADA, the Americans with Disabilities Act, generally, or the neighbor, Americans with Disabilities Act normally does not apply to condominiums and subdivisions. The Americans with Disabilities Act generally only applies to places that are open to the public and serve as public accommodations. So, unless you have, a recreational center or fitness center that's open to people from outside the condominium who are coming into your property, the ADA is generally not going to apply to your operations. And then somebody said, what if it was in the bylaw? Then Sandy likely would be forced to stop smoking. If it said she can't smoke and she was, then it's very likely that she would be forced to stop smoking in the condominium. Parking and towing, another big issue, especially for our associations who are tight on parking spaces. So the Limited Space Association has a problem with parking. The co-owners are assigned parking spaces, and the governing documents say towing is permitted, but they don't have a sign regarding towing of vehicles. Yes, Gary parks in a reserved spot, and the association orders towing Tony to remove the vehicle. So does the association have the right to tow Gary's car? So remove the word sticker from there. Just say, the question here is, do they have the right to tow his car? Someone said no, sign required. Someone says, no, lots of no's. You guys are excellent at your towing rules and regulations. So Michigan state law says, does have requirements if you're going to tow vehicles from private property. And so you'll find that at MCL 257.252K. I won't read you this entire provision, but as all of you very well versed board members and property managers pointed out, you do need to have a notice prominently displayed at points of entry. They need to indicate in letters that unauthorized vehicles will be towed, provide where the towing company is going to be, and also to make sure that it's installed at certain heights. The other second option typically is if you have given personal notice to that individual that their car is likely to be towed. So many times that could be stickering of the car a few times every hours. And so those are your different options, but just be careful. Even though your documents may say you can tow, you should have that sign that complies with Michigan law at your points of entry, or you should be doing personal notices to those individuals that their tow is, or that their car is going to be subject to be towed. All right, moving on, starting to move at a little bit of a clip here. So hoarding. We have here Harriet the hoarder, who lives in the clean living condominium. The board becomes aware that her unit is stacked with garbage and newspapers from floor to ceiling. However, she has created a clear path from the front door to the back door. And so in this case, the question is, what should the board do in this particular case? So let me know your thoughts. Someone said, hey, this might be a fire hazard. Have the housing authority inspect. Somebody asked if slides will be available. They should be, yes. So I will make sure I follow up with our marketing people and make sure that those get sent out. All right. So someone says, hey, this attracts infestations. So in this case, there's two different options that the board can take, and it could take them simultaneously. One, as somebody mentioned, it is possible you may want to contact the local authorities. So particularly have the health department come out, do an inspection, or even the fire department to come out and do an inspection to make sure that that particular co-owner is safe living in their unit. And especially if they're in an attached condominium building, whether that particular unit is going to present a fire hazard and possibly put other co-owners in danger. The second one is typically, especially our condominiums, have provisions that say that you have to maintain your unit in a safe, clean, and sanitary condition. So it's great that she has an avenue to get from her front door to her back door, but it's very likely that this is not a clean, safe, or sanitary condition. And so there also too maybe you can't do anything illegal within the unit. So if there is a code violation from the hoarding, that would be something to possibly pursue as well. And the second question, doesn't matter if she has a mental health disorder. In this particular case, the association does not have to accommodate unsafe or illegal behavior. So if it's going to put, the activity is going to put other co-owners at risk, you don't have to provide an accommodation for that. So if Harriet the hoarder says, hey, like I would like an accommodation to stack my unit up with as much garbage as I want, that's not going to promote a safe environment. And so you don't need to grant that accommodation. And somebody else mentioned as well that, you could call Adult Protective Services. This is another issue, similar to, your emotional support animals, that we just really recommend treading carefully on these, because certainly, if Harriet or another co-owner has, a potential disability, there is a potential risk that they may come back and say that, there's housing discrimination based on their disability. So again, just recommend treading lightly, but at the same time too, you do want to make sure that that unit is in a safe condition, and that co-owner is also in a safe condition as well. And so we just recommend, focus on enforcing, the governing documents and their conduct, and reach out to your local authorities and also to your attorney to help address the situation and kind of weave your way through it. All right, next up, unauthorized modifications and alterations. Another big topic that a lot of you probably deal with on a continual basis. So here we have Hot Tubby Harry, who lives in the Steamy Springs Condominium Association. And the bylaws require board permission to alter the common elements. He installs a hot tub on his limited common element deck that's only for his use. He hooks up the electricity to a wall inside of his unit with a dedicated 220-volt circuit. He fills a hot tub with a hose and does not connect it to the association's water supply. The bylaws are silent on whether hot tubs are allowed, and so the association sues him to remove the hot tub. Is he going to get to keep his hot tub?
No.
Someone says no, didn't get permission, and got another vocal no. All right, so as the rest of your feedback and your thoughts come in, yes, the question is likely no. And so he's very likely not going to be able to keep his hot tub. And so I think one thing you're like, well, it says limited common element deck. It's only his to use. So why can't he just go ahead and put a hot tub there without getting the association's permission? But importantly, the restriction says he cannot alter the common elements, which would include general and limited common elements. So in that particular case, yes, while it's his limited common element to use, he still needed to get permission from the association ahead of time to install it. And so he likely would have to remove his hot tub at that time. And so I think that it's really important to clarify, to check your condominium documents, because they may require permission for alterations to both general and limited common elements. So just keep an eye on that. Next up, Builder Bob's in a wheelchair. He needs a wheelchair ramp. The condominium bylaws don't permit modifications to the common elements without board approval. He submits a plan for a ramp with 25 lights on it that shine into other units. The board meets quarterly and does not meet for 3 months to consider the request. He builds the ramp without approval because he's tired of waiting. The board sends him a letter demanding that he remove the unapproved ramp and lighting, and he refuses to remove them, and the association sues. So who's going to win under the Condominium Act? So Mike says Bob's going to win. Other people says Bob's gonna win. All righty. So this question kind of actually presents two different issues, but as it relates to the ramp, Bob is going to win under the Condominium Act. So to deal with the low-hanging fruit first, the 25 lights on it that shine into other units, it's very possible that Bob's going to have to at least address that and make sure that those lights are no longer shining into other units. So whether it's just removing some of the lights or if it's just repositioning them, he's likely going to have to do that. But in terms of his ramp, he is going to win under the Condominium Act because of MCL 559.147A subsection 4, which basically says that under this provision, a co-owner can submit a request for a modification. And if the association doesn't approve or deny it within 60 days, the co-owner can go ahead and make the proposed improvement or modification without the approval. So in this case, the association, it took them almost 90 days. And so because they didn't, act in a timely manner or within the 60-day period, that ramp is going to be able to stay. I will note too, so under the Fair Housing Act, the Fair Housing Act just requires a response within a reasonable time. So it's a little bit more broader and forgiving under the Fair Housing Act, but if it's a modification under the Condominium Act, you have 60 days to provide a response. So just make sure that you timely respond to them, whether it's an approval or a denial. And it's very likely that Bob would have been able to get this modification anyway. He's in a wheelchair. He needs to be able to access his unit. So keep those things in mind as well. All right, pre-existing common element modifications. Mary buys a unit in Fox Point in 2013. Bylaws don't permit any modifications to the exterior of a unit without the association's approval. Prior owner painted the door, changed the style, the address numbers, changed the lock or style of the lock before the unit was sold without the association's approval. She then replaced her front door handle without approval. That should say in 2015. The association does not discover the violations until 2015 when she changes that front door handle, and they file a lawsuit and they want her to remedy all those issues from both the prior owner and her conduct. And so the primary question here is Mary responsible for the violations of her prior owner? Somebody says yes. Yes. All right, so in this particular case, this was an actual case that our firm handled, and Mary was responsible for the violations of her prior owner. And so in this case, the Court of Appeals basically said, whether it was her seller or her, there needed to be approval. No approval was received. And so the violation remained ongoing despite the sale of the unit that had occurred between the two owners. And so she had to address those violations, and she had to fix all components of her door and bring it back into compliance. So another thing to keep in mind, particularly, if you have a co-owner who is currently violating the documents, you do want to try to nip it in the bud, get them to comply with the documents as quickly as possible. But if there is a change in ownership while you're in the process of that, you're not necessarily foreclosed from still trying to remedy those violations. Right. And in this case, she didn't know if it had been approved or not. But her argument was basically, even if these weren't approved at the time that the unit was sold, basically those violations became null and void. And the Court of Appeals disagreed with that argument. All right, rounding the corner, almost to the end here, security cameras and Ring doorbells. So Safety Stewart lives in high crime condominium. Recently, there has been an increase in packages being stolen from porches in the condominium. Stewart suspects that one of his neighbors may be the culprit, so he installs a security camera without submitting a modification or alteration request to the association, and he positions it in such a manner that he can see his neighbor's backyard, where he believes he is storing the stolen packages. His neighbor notices the security camera and submits a complaint to the association. So how can the association respond? Someone thinks, this might be okay as long as the camera is not monitoring the interior of the unit. If the camera is installed outside, it may have needed to be there may have needed to be a modification or alteration request. Okay, so you guys did identify the two different issues here. One, if the camera was installed outside on common elements, and there's a provision that says you can't make alteration or modifications to the common elements without the association's approval, that would be one particular issue. The second issue regarding the placement of the camera. So as one person indicated, it would depend on where is there a right to privacy. So certainly if that camera was pointed in to where you could see inside the co-owner's unit, so if it was pointed to be directly at their front door to see who's coming in and going out and you could see inside their house, or if it's pointed at a window and you can see inside the window, that's certainly going to be a problem. In the backyard, I think we would need a little bit more facts, but for instance, if there's a privacy fence up, so the public normally would not be able to see what's going on in the backyard, and that camera is kind of avoiding that privacy fence, and that might end up being an issue. But if it's an unfenced backyard and basically anyone can see what's going on back there, then at least in terms of a right to privacy, that may not be as much of an issue. So it really kind of depends on what can the public normally see, and are you kind of overriding that, and really starting to get into places where most of the time the public's not going to be able to see that type of activity. Also too, one thing that we do recommend, particularly regarding these issues, whether it's security cameras or Ring doorbells, is bylaws amendments that require prior approval of any installation of security cameras or Ring doorbell cameras, so the association can verify where co-owners or homeowners are going to be installing them to make sure that there's not going to be an invasion of privacy issue. And also too, particularly whether there's going to be any recording, whether it be recording of videos to where someone's going to go out and disseminate people, doing conduct or their normal activities in the community, or even to sounds, because there is a wiretapping statute. And so if you're recording one of your co-owners without their consent, including their conversations while they're out on the common elements, or maybe you're picking them up while they're talking in their backyard, that could also be another thing that the association would want to regulate. Somebody asked too, what about the use of drones by members? That's another thing that we recommend our associations include specifically within their documents. If you don't have anything addressing drones in particular in your documents, the FAA does have requirements on who can use a drone. So you do have to be, even if it's just for recreational use, you do have to be registered. And they have certain requirements on where you can fly it and where you need to be positioned in relation to the drone. And so there is still a legal framework for it. And you might also have a basis if you have offensive or nuisance activities provision to try to limit that activity. But the more specific your bylaws can be to address that conduct, normally the better. All right, and last typo here. We have signs and lawn ornaments. So secluded gardens, acres, condominiums documents prohibit homeowners from placing any signs, garden flags, and lawn ornaments in their front yards without the association's approval. Religious Rachel places a religious lawn ornament in her front yard without submitting a request to the association. They send her a violation notice and threaten to levy fines if she doesn't remove it. As she walks through the neighborhood, though, she notices several other owners with signs, garden flags, and non-religious lawn ornaments in their front yards, and learns that many of them also did not submit requests. So she refuses to remove her religious lawn ornament. Can the association begin assessing fines against her unit? So someone says after a hearing, and yes, she is in a condominium, so you definitely would want to make sure you offer her a hearing first. Dana mentions, she thinks that they're going to have to go after all the other violators as well. And Dana, I agree with you. Here, the issue is that this is likely going to give rise to a housing discrimination claim based on religion. And so what this really emphasizes, and I think it's a nice one to almost close out our presentation with, is you have to make sure that when you enforce your bylaws, your declaration, that your enforcement is uniform and consistent across the board. And so there have been cases where, particularly regarding religious items, where condominium associations or homeowners associations have not prohibited non-religious items in common area hallways, but as soon as a religious item appeared, they removed those items. And those resulted in housing discrimination based on religion claims. So just make sure that you enforce them equally across the board to limit any arguments that that you're selectively enforcing the documents or targeting a person based on a protected class. So last but not least, there are many enforcement options here. And so for your bylaws, many of them are going to come from your condominium documents. Some of them are just legal remedies. So one thing that may be helpful, particularly regarding when it comes to uniform enforcement and avoiding arguments of selective enforcement and targeting, is considering adopting bylaw enforcement or violation policies that specifically spell out, hey, when there's a violation of the documents, we're going to send you a notice. You're going to have a certain time frame to respond. If you don't respond or you don't comply within a certain time frame, we're going to turn it over, to our attorney to handle further, whatever the mechanisms may be, because it makes it very clear both to the board members who are going to be responsible for enforcing the documents. This is the process we're going to follow, but also for your co-owners and homeowners as well. So for condominiums and subdivisions, if your documents allow you to levy fines, you certainly will have that option. And if you're a condominium, you just need to make sure you give a hearing for that first violation. And so many times the idea of accumulating fines can, interest a co-owner and paying those off and stop violating the documents so they stop having to pay those extra dues. If your documents allow you to record liens, you might be able to record those. I just want to note, though, that they have to be delinquent in their payment. So just because they're in violation of the documents doesn't mean you get to record a lien. You do need to make sure that there is some delinquency there. That also can be a possible tool, particularly if you have been levying fines and they're not paying those fines. Both injunctive relief and money damages, those are legal remedies that are available to both subdivisions and condominiums. Our documents are contracts basically, and they can be enforced in the courts. And so those are potential options as well. Typically, hopefully options of last resort, but unfortunately, as someone says, you sometimes get an owner that basically says, sue me. And sometimes that you've got to move to that aggressive option and pursue, injunctive relief to get them to comply. One thing too that we recommend both subdivisions and condominiums include within their documents, if you don't have them already, is the ability to recover attorney fees and costs, particularly both pre-litigation and also during litigation. And so many condominium associations typically have a provision that will allow them to recoup their attorney fees and costs once they have to file a lawsuit and they're successful in that lawsuit. Subdivisions kind of are hit and miss on those provisions, but those are definitely beneficial provisions to have. And I think it makes it sometimes easier for associations to move forward with that more aggressive option, knowing at the end of the day, the rest of the co-owners may not have to pay for one particular homeowner's misconduct because they decided that they're not going to comply with the bylaws or the declaration. One provision that more associations were starting to see, but we do recommend, is also allowing associations to collect their pre-litigation attorney fees and costs. Many times Some homeowners will decide to comply of like, okay, I don't want any further trouble. I'm going to, correct this violation. And that allows the association to still be able to collect the cost that the association incurred in sending that notice, talking with legal counsel to get them to comply with the documents. And also too, we had discussed this earlier with the electrical use issues or other utility use issues as well. So particularly condominium associations might have this provision, but we recommend it for all of our associations. The ability to levy costs for expenses related to a co-owner or homeowner's conduct. And so that also gives you another option if you're outside the particular, litigation, that you would have that option to, assess those costs back. So with that said, we'll now open it up for questions. So a whirlwind tour of some common bylaw violations, some tips and tricks on, what to think about when you get those, and some ideas on how to levy or use different remedies at your disposal to both get people to comply, but also, to help, finance those actions as well, and make sure that the co-owners and homeowners who are complying with the bylaws and the documents aren't the ones necessarily paying for them. So one person asked here, what if a resident refuses to remove a political sign taped inside in front of the bylaws, and how to handle? So typically with those, we recommend sending, most of the time, our first recommendation is going to be to send a demand letter asking them to comply within a certain amount of time. Many times, though not all the times, many times a lot of co-owners and homeowners want to do the right things, and a lot of them just don't read the bylaws and they don't read all those documents. And so many times, either a notice from the association or property manager or a demand letter from an attorney can get them to comply. And so we normally recommend that as a first step. From there, it really just kind of depends on how your co-owner or homeowner responds. If they don't comply, it may be, hey, at this time we need to move forward with fines. Or, if they're coming off really aggressive, maybe they just have no interest in complying whatsoever, that might need to be where you start looking at possibly filing a lawsuit. But generally, the first step is typically the same. But from there on out, the next steps really kind of just depend on your co-owner and homeowner and how immediate you need to get the compliance, and how they are going to respond to that as well. Any other questions? You can feel free. Oh, by the way, you can now unmute yourself if you want to ask questions. Somebody said, what's the recommendation for keeping track of approved modification requests? Those should be saved as part of your association books and records. So definitely keep those as part of your books and records. And it could be tied to a unit file. So if you want to say, hey, this unit has this particular approval for a modification or request. So that could be an option, though. If it's a more permanent modification or improvement, you may want to have it saved separately so it's not tied to that particular co-owner, because it may pass from co-owner to co-owner as that unit is sold and repurchased. One person asked a great question. If passed, will the short-term rental legislation apply to HOAs? And if HOAs have rules on the books, will they remain in effect? So the current legislation that's pending in the House is for on short-term rentals is in regards to the zoning ordinances. So to specifically say, under zoning ordinances, short-term rentals are going to be considered residential use. Michigan case law is very clear that zoning ordinances and interpretations and definitions within zoning ordinances do not apply to restricted covenants. And so there really should not be an effect of that particular legislation on the meaning of residential under restrictive covenants like your declaration in your condominium bylaws. And so while that's not to say that someone certainly won't try to make that argument, or there may be a shift in court's interpretations of whether short-term rental is residential or not, at least based off this particular zoning ordinance and the current Michigan case law, that definition of short-term rentals being residential and zoning ordinances should not affect what is considered residential under your documents. All right, so some other question. If a co-owner sells their unit, who's responsible for informing the buyer of the bylaws? So your recorded documents, whether they're a declaration or master deed and condominium bylaws, those are recorded and you can find them on your register of deeds. And so Michigan case law says anything that's recorded in your chain of title, you are on notice of. And so when a co-owner or homeowner purchases their unit or their lot, that document is going to be within their chain of title. And so they should technically be on notice of it. Now, will they actually receive a copy of those? Hopefully the title company will give them a copy of those documents when they purchase their unit or their lot. But you know, generally I would expect the title company to provide it to them. It's very likely, you know, maybe their buyer or their seller will say, hey, I have these copies of documents, you'll want to have these. Or to the association, you know, when you get a request from a title company for a status of, you know, how are the assessments, are they paid up or not? You know, you could certainly ask them like, hey, do you have a copy of these? If not, you know, here's a digital copy, make sure you pass these along to the buyer. But there's not necessarily an obligation on the association to provide those to the buyer. They should be aware of it and should be getting it during the purchase of their sale. All right. Somebody asked if an accommodation is allowed, does it carry over from one property management to another property management as the association chooses another company? That my answer would be very likely yes, it should just carry over because the co-owner or homeowner in their particular condition and need for accommodation hasn't changed, just who's managing the association and the property has changed. So again, hopefully your association is keeping great books and records. And so that should just be part of that unit or lot file, and that should just transfer over from one to another. So somebody said, can an association charge for reproducing the association documents, or can they just point owners to a digital copy? So we typically recommend having within your bylaws a provision that says, you know, hey, if we're going to provide you copies of the governing documents or any other books and records, we're going to charge a reasonable fee. The Michigan Nonprofit Corporation Act regarding inspection of books and records does contain a provision that says, hey, if a member is entitled to inspect certain books and records, they can do so and they can copy them, you know, for whatever the cost of the copying will be. But if you do have your documents stored online and you do have a digital copy of them, I think that that's the easiest way to get those to people, especially we've noticed that in the realm of the pandemic where it was hard to get people in the same room with one another or in a room with books and records. So if you have a digital copy and you want to share it with them, you certainly can, or if you have an owners or association website, you know, you can put those digital copies up there as well. So somebody said, our bylaws place the responsibility on the seller to pass along the documents. Is that okay? Yes. Now, is the seller actually passing along the documents? It's another question that you may or may not know because you're not at the closing table, but I don't see an issue with that provision. So Ellen wants to know, is there an effort underway by the legal community to reverse the legislation that expires certain deed restrictions in 2024? So this is in regards to the Marketable Record Title Act, which there was an amendment in 2018, and it has gone through some recent revisions, and there is legislation underway to kind of address some of the potential ramifications of that act. We do have articles on it on our blogs, on our blog called micondolaw.com. So if you want to type in the search bar, Marketable Record Title Act, you can look at it in more detail than what I'm going to be able to provide you here. But basically, the Marketable Record Title Act just says, you know, when you buy a piece of property, there's going to be all these restrictions, you know, from the past historically on the property. And we're really only going to hold you, a purchaser, responsible for those restrictions that pop up in the last 40 years of your chain of title. Because, you know, if you start going back 100, 150 years, you know, that may be difficult to keep track of. And so typically the way when people purchase their property for years and years, if you look at your deed, you will probably see it. When you got your deed, it said you're purchasing this lot or unit subject to easements and restrictions of record, if any. Just very vague. They might be out there and you're subject to them. Title companies did not like this provision because it made it very difficult, because who knows what those restrictions are. And, you know, it made it difficult for them to insure properties when there's any number of easements and restrictions that may exist out there. And so in 2018, an amendment was made to say, you can't just say subject to easements and restrictions of record, if any. You have to specifically call out the library and page number in order for those to remain in effect, for somebody to be subject to them within that 40-year period window. And so, you know, basically just making it easier for title companies, realtors to do their job. But with that said, there are, of course, among community associations, was certainly a lot of concerns, because some of our master deeds are older than 40 years. And so, you know, there was an argument of, are we all of a sudden not going to have any of these restrictions? Is it going to become lopsided depending on, hey, my chain of title specifically calls out the library and page number, but yours doesn't? There was a push to have documents updated by, I believe it was March 2020. We have now, there was a push to get it extended to March 2024. So there's still a window of time for associations to take a look, see if they need to record basically a notice to say, hey, these are our restrictions. They're located at these documents and you all are bound by them. So there's still a window here. But yes, there is an effort underway to try to get an exemption specifically for condominium and homeowners associations, that they would not be subject to the ramifications of that particular act. So stay tuned. So somebody said, can an association make the owner undo an accommodation when the unit changes over, such as removing the ramp? So typically the answer, again, is going to be, it depends. Largely, it depends on who's buying the unit. So if the co-owner is selling to somebody who also requires that same accommodation, you're not going to be able to make them remove it, because that new owner is going to require it. But otherwise, typically in the MCL 559.147A does say, you know, once a co-owner decides to move, they need to let the association know. And, you know, then that co-owner is going to have to remove that particular modification, unless they have someone coming into the unit who's also going to require that accommodation. So in terms of the Marketable Record Title Act, in terms of the notice, whether do all HOA members need to vote on and approve filing that notice under the Marketable Record Title Act? I'm going to say I don't believe so. But I would recommend reaching out to us if you're interested in doing that. We have done it for some of our associations. I don't believe that they've required a vote, but your documents and situation might be different. So I would just recommend reach out to us and we can give you a better, a more tailored answer, I should say. Okay, so next one. Okay. So someone says, when the title company notifies the association of a pending sale, the common element and limited common elements are expected and CCE requests are checked. The findings are relayed to the new owners, where I'm guessing that's potential violations of the documents. Is that okay? Yes. And I actually do recommend, if you are aware of current violations attached to a unit that have not been resolved, and the title company asks you for a status, to make sure that you convey that information to the title company so the buyer is aware, like, hey, there are outstanding violations here. So that way there's not an issue. The buyer comes in fully aware that there's existing violations. And it's very likely the buyer will force the seller to get those taken care of before the sale is completed. So somebody asked, should something be added to the modification request form to notify the owner they'll be required to remove it unless a new owner requires it? I don't want to say that this will necessarily be a provision that will apply in all circumstances. And so as you can imagine, there are likely going to be some modifications and improvements that once installed are going to be very difficult to undo, and they cost a lot of money just to undo. So typically what we require or what we recommend is, if it's something that will, be easy to remove, or the co-owners agree, they'll remove it when they move, include that language within the agreement. But if it's something that's going to be more of a permanent modification or improvement, we'll want to have within the modification agreement that the obligations attached to maintaining, improving, repairing, being financially responsible for that modification are going to run to their subsequent buyers. And typically with that too, we would recommend recording that agreement with your local register of deeds. So when the buyer does go to purchase the unit, that document should pull up in the title company search. Let me see. So I don't see the full name here, the K. Loy. If you want to unmute yourself so you can just explain your question to me a little bit more so I can make sure I answer it.
Sorry.
No, you're fine.
Hi. So when we find that the change of common elements have been granted and it requires the co-owner to maintain whatever that change might be.
Right.
However, over time, they stop paying the cost, and then that cost shifts back to the other co-owners because it's not enforced.
Mm-hmm.
How should we address that?
So it sounds like you have an alteration or modification. Ideally, what you would have here is an alteration or modification agreement that expressly says, hey, you co-owner, you're going to be responsible for paying for this. To the extent that they're not, that modification alteration agreement should be a contract. And so you should be able to enforce it against that co-owner. And so you should be able to go, hey, as a condition of having this, you said that you were going to maintain it. You're not maintaining it. And so, it's a breach of this agreement and you need to do it. Sometimes as well, you can include within those specific provisions that say, hey, if you're not going to maintain it, then, we, either the association, we're going to have the right to come in, maintain it for you and assess the cost back to you, or possibly require you to get rid of it. And so it might just be a situation of, adding in a few more remedies into your modification alteration agreements.
Thank you.
Sure. And also anyone can unmute themselves as well too if they want to answer questions. You don't have to just throw them into the chat box. So Anybody else? I'll give you a few minutes in case if you have just some dying questions that you would like to ask. But otherwise,
Can we go back to the animals at meetings? Sorry, my light goes out automatically. Can we go back to the animals at meetings and how we work through that? If it's a closed quarters and someone has an animal, gosh, now it just slipped my mind, but
yeah, like a service animal. Or
yeah,
an
service
emotional support
animal, and there are individuals who are in the meeting who are allergic to the animals. And what if the majority in that meeting were allergic, and if they weren't there, you wouldn't have a quorum, and so you'd have to.
Yeah, I will say that that is not an issue that I've seen before because it's very specific to like a board member meeting, it sounds like. And so I think I would just kind of re-emphasize in that particular situation. I mean, you're kind of stuck between a rock and a hard place, right? You have one person who is entitled to this accommodation. You know, they need either the service animal or the emotional support animal for some particular reason. But at the same time, you also have, you know, co-owners and homeowners who have allergies, and you don't want people sniffling, coughing, especially in COVID days.
Right.
And so I think in that sense, I mean, I really think with Zoom and conference calls, like everyone has really learned how to connect remotely. And so I think the best way to do it, that's, you know, the less like least contentious route is just to say, okay, we're going to acknowledge everybody's situation here and we're going to meet via Zoom or we're going to have a conference call. I think that that's just kind of the cleanest way to deal with it.
Thank you.
Anybody else? All right. Well, seeing none at this time, I will go ahead and call this seminar to an end. So like I said, I will reach out to our marketing people and make sure that they make the slides available to you. This also was being recorded, so I believe it will be available on the back end. If you really just love listening to my voice and would like to hear me go through all this again. But otherwise, thank you all for joining. And if you guys have any other further questions, feel free to reach out. Check out our blog website. A lot of these topics we've written blog articles about, so you can get even more and better information there. But other than that, enjoy your upcoming holidays, and I hope you don't have too many bylaw violations you have to deal with in the meantime. So thank you all.